All right, well, we will get started. Thank you so much. We have our two candidates here for the Commonwealth's Attorney's Office, and we will ask that each give an opening statement. Yes. Oh, I'm sorry. Would you pass it to me?
So good evening. My name is Josh Katcher, and I am a Democrat and a reformed prosecutor who believes that there is a way to uphold public safety, respect victims, and improve our justice system. I've been a prosecutor for 11 years now. I work for both Theo Stamos and my opponent. One hired me, one promoted me to Deputy Commonwealth's Attorney. While working for a person does not mean that you necessarily share all of their beliefs. Theo and I have some deep philosophical disagreements. I don't believe in the death penalty. I believe that simple felony possession of controlled substance charges should be used simply as a vehicle to get people the treatment they need. And I've said publicly for quite some time that I do not believe that felons should lose their right to vote upon conviction. But I also have some disagreements with my opponent. I believe the Commonwealth Attorney should prosecute cases themselves in court. I believe justice for victims should be central to a prosecutor's mission. I believe deeply in transparency. In my administration, you won't just have to take my word for it that I'm fulfilling my campaign promises. And I'm proud that my campaign is financed by individuals from this community. But our community is facing rising crime. There is no relationship between our prosecutor's office and the police department. We have a Commonwealth Attorney's Office where line prosecutors are not being set up to succeed. And the data transparency that we were promised has yet to materialize. I'm running because a failed execution of reform prosecution will be misinterpreted as a failed philosophy, and that would be terrible. This is not the reform we were prosecuted or that this community wants. I'm a lifelong Democrat who believes in public safety. There is a way to do 21st century reform prosecution. With a well-run office, one that is founded on accountability and decency, there is no reason that we cannot be the best example of how to do reform right.
Thank you, Josh Katcher. Next, Parissa Dagani-Tafti.
Good evening, friends. 4 years ago, we were the most regressive jurisdiction on criminal justice in Northern Virginia. Many defense attorneys refused to practice here. Black people were charged at a 50% higher rate of seriousness, even when you controlled for all factors. And by the way, we only know that because of the data that I worked to collect and release in 2020. Defense attorneys were forced to come in and copy discovery like high schoolers in detention. The office called our legislators silly when they suggested not asking for cash bail and forced defendants to plead guilty by charging with the death penalty, overcharging, stacking charges, and threatening mandatory minimums and mandatory jury sentencing. We had no restorative justice, we had no mental health court, we had no adult diversion programs. And when I ran to change that broken, unfair system, my opponent was working in that office every day, going along with these practices. And he didn't have the courage in 2019 to stand up and run. He even defended his mentor and begged Arlington voters to keep the status quo, calling it a shining example of progressive prosecution. But the community didn't listen, and during my first term, we've completely transformed the office. We stopped asking for cash bail. We helped create a mental health docket and a restorative justice program. We've quadrupled the number of people in drug court. We've established a free expungement clinic, protected immigration status, and are protecting reproductive freedom. Arlington has become a model for criminal justice reform around the country, and it's ranked the second most desirable place to live and in the top 15 of the safest communities in the nation. So who can we trust to protect this progress? The Washington Post trusts me. The Educators Union trusts me. Representatives Don Beyer, Jennifer McClellan trust me. Senators Favola, Sasla, Lucas, Serval, Delegates Hope, Simon, and Lopez.
Thank you. The opening question, in addition to all of the questions tonight, will be for a 2-minute limit. And the first question, the opening question, will go to Josh Katcher to answer first. Mr. Katcher, what do you believe to be the biggest issue facing the Commonwealth Attorney's Office and why? How will you address it if you are elected?
I think if we want to truly deliver on the promise of 21st century reform prosecution, we need to look at the way that the cases are being handled by the prosecutors in the office. And that's why I've spoken so much during this campaign about an office that's in free fall. We know that 14 attorneys have left in the past year and a half. We know there are between 7 and 9 fully funded vacant attorney positions in the office. That places undue stress on the line prosecutors within the office. And that's why I said we have an office where line prosecutors are not being set up to succeed and do the very difficult work that reform prosecution requires. So the most important thing we can possibly do is restaff the office to make sure that it's up at its full capacity so that line prosecutors have the opportunity to train and grow and get supervision and have the mentorship necessary to do the difficult work of reform prosecution. Furthermore, the more senior prosecutors shouldn't have to be overwhelmed handling serious cases. We've got rising crime in Arlington, and if we have a declining number of senior and experienced prosecutors in the office, that makes it all the more difficult to address the additional very serious cases that are coming in on a regular basis. Because obviously an individual who's going to be handling serious cases should have an opportunity themselves to work on that case. And if they're getting pulled in multiple different directions, that's going to undermine the overall ability for them to engage on that matter. So I think the number one thing we need to do is rebuild our office and set it up for success.
Thank you. Parissa, what do you believe to be the biggest issue facing the Commonwealth's Attorney's Office and why? And how will you address it if you are reelected?
I think the office is on an excellent track, and the biggest issue right now is my winning reelection, because morale has never been better in the office, and we have an excellent trial record, and I actually have a graph for that shows that we've been doing significantly better at trials in obtaining guilty verdicts than my predecessor, as well as creating transformational change within the office. We have a diverse team, both in terms of professional and personal backgrounds, and I think that we have really shown the nation what a progressive office can be.
Thank you. Next question goes back to Parissa. The subject is cash bail. Your campaign has focused on the promises you previously made, including an end to cash bail. In practice, in many cases, this has resulted in your office reading police reports and criminal history backgrounds to judges, deferring taking a position so as not to request cash bail, and often leaving people who should not be held without bond or with a high bond because no options were presented to the court. If your policy position is no cash bail in any circumstance, why doesn't your office offer alternatives in every eligible case instead of leaving it to the court's discretion?
Well, the job of the courts is to call balls and strikes. And so the court is always going to be making a decision, and the court is always going to be exercising its discretion about what it's going to do. We never ask for cash bail because we don't want to criminalize poverty, but we also don't ask for cash bail because we don't want people who we think are dangerous and potentially flight risks to be out in the community just because they can afford to be out in the community. So we've struck that balance precisely so that we can be intellectually honest about why a person should or should not be held. And we've tried at every opportunity to create diversion programs and to participate in bond diversion and to try to get people out in the community in the safest way possible. And we have had a jail population that is historically at its lowest that anybody can remember consistently for the last 3 years.
Thank you. Josh, if you are elected to serve as Commonwealth Attorney, what will be your position on cash bail? And will you follow your predecessor's policy of deferral in serious or complicated cases?
When it comes to cash bail, I think it's important to start with values. And so the question is, what does exactly cash bail mean when we're talking in this context? Here's what it actually looks like. People get arrested on the street, they go before a magistrate if they're not released on the street. The magistrate then sets a bail. There's then an arraignment hearing. Oftentimes the prosecutor is not going to be involved in the arraignment. So the first opportunity a prosecutor is going to have is at the bond hearing when the defense attorney puts on a bond motion. And so what happens then is the prosecutor has to make a determination based on all the available information both in the police report, criminal history, working with defense counsel, maybe what they've heard from police officers. And then, this is the important part, it should be a binary situation. We either agree that the person should be released on conditions, or we oppose it and say they are a flight risk or a danger to the community. So that is the high-level philosophical position. And I think in that regard, we agree. The one difference I can tell you is, having actually been down in the trenches and seen how this is working, people are deferring to the courts. And I think what we need to do is be honest and intellectually consistent. If we're going to take that position, which can sometimes be difficult, we need to be following through with it all the way through. And I think that's why it's important to have a Commonwealth's attorney who's going to be down in the court to actually see how this is working.
Thank you. Next question, Josh, it will be you again. The issue is charging decisions. Prosecutors can use their discretion when deciding the nature and the severity of crimes to charge an accused and the length of sentence to seek from a judge. What factors do you take into consideration when making these decisions for adults and for youth?
It's a very large question for 90 seconds. As it relates to kids, my default positions are always going to be kids should not be in the justice system. If they are going to be charged, we should not be transferring them as an adult. I think that is just table stakes as where we are in Northern Virginia. That's where we are in the reform prosecution movement. And I think as it relates to kids, that has to be our standard policy going forward. As it relates to adults, I think what might be being referenced here is when we have a case that comes in and there's charges that are cumulative or duplicative, the question is, do we leave them there and then use them as leverage, or are we honest on the front and say, you know what, this is not something that at this point we think that we need to go forward on because the gravamen of the facts of the case, the relevant part that we would be seeking to hold someone accountable for, is already contained in the other charges. I agree with that. I think that's what we should be doing. I don't think we should be stacking up charges and trying to force people to get pleas out of that. What we want to have is a real honest opportunity for the moment of accountability to be arrived at because of the adversarial system, not just because someone feels like they've been leveraged into accepting a plea offer.
Thank you. Parissa, same question. Prosecutors can use their discretion when deciding the nature and severity of crimes to charge an accused and the length of sentence to seek from a judge. What factors do you take into consideration when making these decisions for adults and for minors?
I've said from the beginning that we should treat kids like kids. I said that in 2019, and I've certified 0 children as adults and asked for 0 children to be transferred into adult courts. It's funny that my opponent says that now, and yet he's weaponized the horrendous pain of a family to make a political point about, and it's just incomprehensible to me, when the policy would be the same. In terms of other issues, mandatory minimums are a big driver of mass incarceration, and they don't allow a court to make subtle and nuanced judgments about what a person what time the person should serve, but also what the conditions could be and suspending sentences and that sort of thing. So what we try to do is not charge mandatory minimums, particularly because they're coercive. There are exceptions to that, and clearly sometimes those need to be charged, but we try to not charge mandatory minimums to have the wide range of possibilities for sentencing. And my opponent, as I said, worked in an office and advocated for an office that regularly stacked charges, that regularly used mandatory minimums. And so, I'm happy to hear his conversion, but, he didn't have the courage to talk about any of this until this year.
Next question, back to you, Parissa. Law enforcement relationship. According to the Arlington Coalition of Police, you stated at the Civic Federation debate that your office and the Arlington County Police Department enjoy a, quote, healthy, end quote, relationship. The coalition said that your statement, quote, could not be further from the truth, end quote. It added that the most common recurring complaints from members of the coalition about your office is the lack of preparation from the prosecutors, subpoenas either not being issued timely or at all, and the lack of communication between your office and police officers about cases and outcomes. How do you respond to this criticism, and what are your plans to restore the relationship?
It's not surprising to me that the coalition would come out in favor of my opponent and say these things, considering that they came out in favor of my opponent in 2019, and considering that my opponent has bragged about going on vacation with the president of the coalition, and has even engaged the Arlington County Police Department to prank somebody in a really tactless way. What I can tell you is that for all this alleged lack of preparation, when you look at the conviction rate at trial on the top charge, we are at 72% guilty on the top charge. The prior administration was 57%. When you look at the conviction rate at trial on one or more charges, 75% versus 64% with the prior administration. And I would just add that when Chief Farr retired, he said the word was that he retired because of his relationship with me. And what he said was, while it is true that Ms. Tafty and I do not look through the same lens all the time, we did strive to see common ground wherever possible. On those occasions where there was a difference of opinion, I found Ms. Tafty willing to consider the police department's position. Overall, we had a very professional and respectful relationship. And I will add that the Beneficiary Association President Rich Conigliaro also told All Now last July that the crime rate, police officers working with Degani Tafty generally approve of the way her office pursues violent charges.
Thank you. And Josh, in the same statement, the Arlington Coalition of Police said, "We know Josh will get the relationship between the Arlington County Police Department and the Commonwealth Attorney's Office back on track to where prosecutions are a collaborative effort between the two departments." What do you say to critics who worry that this could mean retributive versus reformative or restorative practices and policies under your administration if you are elected?
So I would start by noting the response to the last question from my opponent, how little bit was actually responsive. What you heard was a personal attack based on something that happened 8 years ago. You heard something about my hanging out with the president of ACOP, which is an allegation that I've heard repeatedly tossed out at these debates, and yet have literally no idea what she's talking about. And then finally, we have a discussion about conviction rates, which again, has nothing to do with the police department and the relationship. If we truly care about reform prosecution, we need to have our closest law enforcement agency partner actually working as a partner. Wearing animosity towards the police department as some type of badge of honor literally makes no sense for this endeavor that we're engaged in. As for what I would like to do with the police department, front and center on all of my litter is the fact that I'm a Democrat, that I believe reform prosecution is the way to go forward, and I tell everyone, both publicly and privately, we have a police department that is ready, willing, and able to assist us in this if they just had a relationship with the Commonwealth Attorney's Office. We have an educated, introspective, highly trained police department here in Arlington County. They are not the type of people that became police officers because they want to go arrest people with syringes hanging out of their arms, or sleeping on a bench, or having a mental panic attack in the middle of the street. These are the type of people that want to find better ways for them out of the system so they can get onto a better trajectory. Those are exactly the type of partners we should be asking for, that every reform prosecutor's office would love to have. We have them here in Arlington County. If we truly want to deliver on the promise of 21st century reform, we have to repair that relationship. So I'm proud to have that endorsement, and I think it's going to go a long way to getting us to where we need to go.
Josh, next question for you. This topic is reform. What efforts at criminal justice reform have you initiated, and or can you describe a creative or, quote, reform, end quote, outcome you proposed on one of the cases you personally handled?
So I have a story. Many years ago, we in the office, there was a charge that you could be prosecuted if you were a habitual drunkard. It's a ridiculous law because obviously addiction is a disorder, right? So people who are individuals who can't help from drinking, the office was prosecuting them for this disorder. So one day, I had a case and it landed on my desk, and I said, you know what? This is ridiculous. Why are we going to continue to prosecute this man? He has just finally got set up with a program, and he had a minor slip. And we know that addiction and recovery is never going to be a straight line. So I went into my deputy at the time and I said, this is a kind of a creative outcome that I want to do here, but I don't want to go along with our standard way of continuing to, seek a prosecution, maybe put them on some type of deferred adjudication, give them some help. Instead, there was a relatively complex program that we came up with, myself and the defense attorney, and then we went in front of the judge and we pitched the judge on this. Now, I will tell you, if you go back and you look at my personnel file, I got in trouble for it because I was kind of told to do something other than that. Nonetheless, I think that's exactly the type of reform work that we need to be doing, because we need to be willing to be creative and find opportunities to come up with solutions that are not going to result in convictions or incarceration. So I'm proud of the work that I've done, and I've always said that about substance abuse. We are not going to incarcerate our way out of substance abuse. I've spent so many Fridays doing the sentencing dockets up in circuit court where I see so many people who are on the back end of convictions for substance abuse or something that was prompted because of substance abuse. And every single time I see that, I think to myself, if we had external off-ramps that would have addressed this problem before they found their way to the justice system, this whole thing that we're involved with here would just be so much better.
Parissa, you have said that your office has not certified or transferred any youth to adult court, implemented a behavioral health docket, did not prosecute cases involving simple possession of marijuana cases, and implemented a community oversight board. What do you say to those who say that it was the prior administration's policy not to transfer children, the behavioral health docket was implemented or in the process of being operationalized during the prior administration, the decriminalization of simple possession of marijuana was a legislative reform that occurred at the beginning of your term, and the Community Oversight Board was the product of the county's police practices group? What criminal justice reform initiatives are solely through your efforts?
Well, I need that list so that I can respond to all of those, but what I will say is that not prosecuting simple marijuana possession was a policy. I supported the legislature in decriminalizing and legalizing, just like I supported the legislature to abolish the death penalty. And that's the work, that's the policy and advocacy work that the Commonwealth's attorney does, that my predecessor did the opposite of. And in terms of the behavioral health docket, that had been sitting around and discussed for 15 years before I ran in 2019. And there was a big rush to do something because of the election in 2019. Ultimately, I helped shepherd it through and make it the kind of program that would actually be effective because it did not require somebody to plead guilty. We have a peremptory strike policy that's designed to have more diverse juries that I implemented. Our mandatory minimum policy, I implemented. The consideration of immigration consequences so that we don't improperly separate families, I implemented. Every one of our policy documents, which are publicly available, are things that I implemented. And I implemented them in a way that incorporated the feedback of my staff. And the peremptory strike policy is the perfect example of that. Because I wanted to say no peremptory strikes, we waive peremptory strikes, period. And my staff, I put this to the attorneys, and the attorneys came back with, well, we have a few different circumstances, and what would we do in these? So together, we created a policy that was a waiver accept policy, which the NAACP Legal Defense Fund has called a model policy, which they are trying to shop to other prosecutors' offices.
Next question again for you, Parissa. This is on community representation. The Commonwealth Attorney is elected to represent all residents of Arlington County and the City of Falls Church. Your campaign has made an issue of your challenger receiving donations from individuals who identify as members of another party. Why is that an issue?
I'm glad you raised that. It is an issue because it shows that he is taking money from people who have actively opposed reform. He's taking money from people who have donated to Miares, who've donated to Glenn Youngkin, who've donated to Josh Howley, who've donated to Amanda Chase. What that tells you is that you don't just get that kind of money by being a reformer, when these people have supported the opposite of reform, when these people have called reformers people who support criminals first. And you're not getting $5,000 from somebody who gave Glenn Youngkin $41,000 by getting on the phone and saying that you're a reformer. And what it tells you is that he's saying one thing to one audience, another thing to another audience, and that you cannot trust him.
Josh, your campaign has outraged your opponent during each reporting cycle. She is the incumbent, and your campaign expects that she will receive large PAC contributions. How do you reconcile your opponent's complaints about your donors with your campaign's complaints about her funding?
I think it starts by acknowledging that I've been around in Arlington politics for 12 years. I've been in the Democratic Party at the highest levels. And to suggest that somehow I'm not a Democrat is absurd. But also from that experience is the following. At the end of every local campaign, the supporters of the side that feels like it's losing starts engaging in these baseless personal attacks. I've seen it every single time. In the past 2 weeks, I think I've been called sexist, racist, an extreme Trumpist, and most recently, a Nazi. Which, the last one is particularly interesting because I'm Jewish. But this nonetheless is what happens at the end of every campaign. Now, in a way, it's extremely frustrating. In a way, it means that we're doing something right when my opponent's supporters have entirely abandoned the substance of the argument. But let's talk about this idea that I'm somehow secretly soliciting Republicans. We are not actively encouraging or looking for Republican support. Front and center on all of my literature and what I say publicly and privately is that I'm a Democrat and I believe in reform prosecution. More importantly, the numbers that are being thrown out, one of the things that I've said during jury trials for years is that saying a thing doesn't make it true. And that's exactly what's going on here. We looked into our actual numbers to find out how many people would conceivably be classified as Republicans, because keep in mind in Virginia, you don't actually identify as a Republican. And it's low single digits, all of which who live here in Arlington County. So these are people who just decided that they were interested in what was happening in their Commonwealth attorney's race. We were not actively soliciting them, and they gave us money. And on the back, and when it's coming in, we don't get a chime that says, oh, you got money from Republican. That's not exactly how fundraising works. As for the idea of the money that's going to be coming in from outside of this county, we take pride in the fact that we've raised, I would say, 98% of our money from within the Northern Virginia region and specifically from Arlington County. That means something, that our community is so focused on what's happening in this race.
Next question will be yours, Josh. The topic is domestic violence. There is concern that cases involving domestic violence or abuse of children are not being prosecuted under this current administration. Would you agree with this sentiment? And if so, what would you do to change the narrative?
Well, the problem, anecdotally, that is what I'm hearing from police officers, from people who are still in the office, from people who are in the community experiencing these awful outcomes. That is what we're hearing anecdotally. And yet, because of a lack of transparency, I can't provide you with the information that would back that up. And that's, of course, the struggle here. And that's a problem, because in the long run, when you're knocking on doors in the community and people are telling you about an awful experience they had with the Commonwealth Attorney's Office, that leads to them losing faith and trust in what's happening in our top elected law enforcement office. So how do you change the narrative? Well, first, you got to be willing to go down to the court and do it yourself so you know exactly what's happening in your own office so that you can talk to people and train people how to do the job. Second, I'm going to go back to transparency. I think it's a core value for reformers to want to be able to let people to independently come to their own conclusions about whether or not we're fulfilling our campaign promises. You've heard mentioned tonight twice to a graph about a conviction rate. I don't know if that information is publicly available. I would love to see it. I think it'd be helpful for the community to be able to independently look at that and answer the question themselves. What's going on here? How many cases are actually being tried? What type of cases are being tried? But again, we don't know that. And I think that's a core campaign complaint that I have. We're talking about things and we want to have a substantive discussion, and yet the answers to the questions that would enable us to have that argument are hid behind a wall at the Commonwealth Attorney's Office. We have to do better.
Parissa, in the past 3 years, how many domestic violence cases have been tried by your office, and what were the outcomes for the majority of the cases?
I mean, I don't have that information off the top of my head, but what I can tell you is that our policy is to, number one, put the victims first. We are never going to coerce somebody into participating in a prosecution, because the most important thing to do with domestic violence victims is to build trust and relationship so that they can feel safe. And I can also tell you that we would never prosecute the victim of domestic violence just because she fought back, which is something that my opponent has done.
Next question goes back to you, Parissa. Immigration and collateral consequences. Your office takes into consideration the potential immigration consequences that a criminal conviction may have on someone who is charged with a crime. In some cases, including felonies, your office has agreed to the reduction or the dismissal of criminal charges because of potential immigration or other collateral consequences. Does your office agree to reduce or dismiss the same charges for individuals who are not facing potential immigration or other collateral consequences? What policies does your office have in place to ensure that this does not lead to unequal treatment under the law?
Well, we have a DUI deferral program that we created precisely for this reason, to make sure that everybody was treated similarly, particularly on their first offense. But what I will say is that it is really important to make sure that somebody doesn't lose their DACA status because they got caught drunk and charged with a DUI. What that does is it quite literally separates families. And so we try to, and we even vacated a conviction. We got a conviction vacated because somebody was given incorrect immigration advice and was on the verge of being deported. And we literally saved her from being deported because of a drug possession that she had been charged with. So yes, I think it's important to not punish somebody disproportionately just because they're an immigrant. I think it's important not to literally rip people out of their home, away from their families, put them in circumstances where they are sent to a country where they don't know the language, maybe can't read or write the language, because that is a result that is just absolutely disproportionate and I think unjust. So what we try to do is produce just results, and we try to do that for every case.
Josh, you have said that reform prosecution involves tailoring outcomes to the circumstances. How will a catcher administration address matters in which there are immigration or other collateral consequences? What policies will your office implement to ensure equal treatment under the law?
That's a great question. So when I talk about reform prosecution, here's how I describe it. Draw a line. On one side, you have those cases that the community rightly wants to see prosecuted. Murder, rape, robbery, gangs, guns, serious drug dealing, crimes of violence. On the other side of that line, you have those cases that I think generally we could describe as vulnerable populations who have arrived in the justice system. The mentally ill, the unhoused, the addicted, kids doing dumb kid things, and if there are people here who have legal or immigration status that is going to potentially result in them being deported because of a conviction on something. Now the question is, what side of the line does someone with that type of status fall? If you have someone who's engaging in an MS-13 gang act of violence, I don't think I'm going to be particularly focused and concerned about them potentially being deported, because what they're doing at the end of the day is an egregious act within our community. But what you're really doing is asking which Commonwealth's attorney and which Commonwealth attorney's office is going to have the experience and the ability to determine what side of the line case is going to fall. If you have someone who's in this country and they've got status that might potentially cause them to be deported because of, say, a petty larceny conviction for $65, and it's their second conviction for that ever, is that an appropriate case that we as a community want to see someone deported on? Of course not, right? But like, how do you ultimately come to the conclusion which one of us is going to do that line drawing exercise better? I can tell you this, it takes developing a basis for comparison. I have prosecuted hundreds of cases in front of judges. I've done more than 50 jury trials. I was specifically entrusted by my opponent to train up the next generation of reform prosecutors. And from that comes an ability to let people know, this is what side of the line we, the community, want to see it fall on, and this is the other side of the line. I think I have that experience, and I think I bring that to bear in the office.
Next question goes back to you, Josh. This has to do with mandatory minimums. Your opponent signed a letter from the Virginia Progressive Prosecutors for Justice on March 8, 2021, urging legislators to eliminate mandatory minimum sentences because, quote, they lead to the irrationally lengthy prison sentences that fuel mass incarceration while exacerbating the racial and socioeconomic inequities that have come to characterize our criminal justice system, end quote. What is your position on mandatory minimum sentences?
I think mandatory minimums unnecessarily hamstring prosecutors, defense attorneys, and judges. By and large, I am not in favor of mandatory minimums. There's a better way to do this when we have maximum flexibility. That being said, we are not the legislators, and so right now we have to work within the confines of the system that we have, which means that sometimes there are going to be cases where the only charge that is going to adequately fit to the facts might have a mandatory minimum associated with it. That being said, there are other instances where there are sets of facts that are susceptible to charges that may have a mandatory minimum and maybe don't, but that we can otherwise come up with an appropriate sentence without necessarily tying our hands. If we could magically wave a wand and make many if not most of the mandatory minimums disappear, I think that would be a good thing. But unfortunately right now as the prosecutor's office, we only have certain tools available to us. By and large, I think mandatory minimums unnecessarily handicap us in our efforts to come up with flexible, nuanced, contextualized dispositions.
Marissa, your office has and currently pursues mandatory minimum sentences. Why, and has your position changed?
We pursue mandatory minimum sentences only where we have to. For example, for a second or subsequent rape, it is important for the jury to know that somebody has a conviction already for rape. So that is a mandatory life sentence. I hate that it's a mandatory life sentence. I think that the judges should be able to have appropriate sentencing. But I also think it's really important in a case like that, and we litigated a case like that exactly that case, that the jury knows that because the person's history is relevant. So yes, we do use them on occasion, but we try not to use them in most drug cases, for example, because a possession with intent to distribute third is a 10-year mandatory minimum. And we try to minimize the circumstances under which we use them. In a way, if we can charge around it, if we can be accurate, if we can be fair, and if it's not a situation where it puts the community in danger, then yes, we avoid using mandatory minimums. But I'm not going to back down from using a mandatory minimum for somebody who is a serial rapist.
Next question back to you, Parissa. School lockdowns is the subject. There have been lockdown drills at nearly all of our public high schools and middle schools in the past 3 years. These lockdowns are the result of threats of guns, bombs, or weapons. Students report being anxious and scared given the current national landscape, but many also cite that there is little accountability for young people who engage in these criminal acts. How do you respond to our youth who feel the current systems and practices are not working?
So we've had lockdown drills for more than 3 years. I remember when my son went to kindergarten, he's 15 now, I was apoplectic that there was lockdown drills going on. And the problem that, the source of this problem is the fact that we are a country that is just drowning in guns. And until we get a handle on banning assault weapons, until we get a handle on background checks, until we get a handle on making it harder to get weapons, until we stop giving citizens weapons of war, until we stop allowing them to buy armor-piercing bullets that can kill police officers when they're trying to help, we are going to continue drowning in this sea of guns. And that is exactly why I'm doing the preventative work that I'm doing with Brady United, with Moms Demand Action, because we are working on lobbying for common sense gun programs, but we are also working on violence interruption. We are also working together on a gun buyback program, and we're working on a gun buyback program that is innovative, and we need to get, work harder to get the ordinances changed and the process in place. But we are doing the work of preventing gun violence, and that is the key and most important thing.
Josh, same question. How do you respond to our youth who feel the current systems and practices related to school lockdown drills are not working?
As I understand the question, it was more about their anxiety.
Students report being anxious and scared given the current national landscape, but many also cite that there's little accountability for young people who engage in these criminal acts. How do you respond to our youth who feel that the current systems and practices are not working?
So I've knocked about 3,500 doors in Arlington at this point. And one of the things that I've heard from so many parents is essentially what was just asked. What are we going to do in the schools to make sure that our kids feel good, but at the same time so that certain things are being disciplined? And as the Commonwealth's attorney, I think sometimes we need to be candid about the limits of what we can do. I'm not running for school board. I don't have the answer specifically there. So then the question and the discussion always becomes, well, what can the Commonwealth attorney do? Here's how I respond to that. First off, I think a Commonwealth attorney needs to be on the 4th floor of the courthouse trying cases in the Juvenile Domestic Relations Court. Not only can, but should, because you learn so much about what's going on in our schools right there. I think there's, when you go one step higher, a real opportunity for the Commonwealth attorney to receive intelligence and share intelligence within our community. That's why one of my promises is that my deputies and my line prosecutors are going to be going to PTA meetings and Civic Federation Association meetings so that we always know what's going on. I go back to the unfortunate overdose that happened at Wakefield months ago at this point, and it was something that feels preventable because if you talk to administrators and teachers, everyone kind of knew a piece, but no one was pulling it together because everyone wanted to stay in their own lane. They wanted to stay siloed. That is not going to be the type of elected official that I am. If I see something and I know something because I'm hearing from our vice detectives that fentanyl is coming into our schools, I'm going to talk to the APS superintendent and say, this is what we're hearing. Do you guys have a plan? Doesn't hear like you have a plan. So unless you guys come back with a little bit of a better plan, I'm going to start publicly talking about this because this community needs to be aware of what's going on. And I think that's the approach that we should take. We should, as the Commonwealth attorney, use our bully pulpit on local issues of that nature that we have a specific opportunity to get unique intelligence on. And I think as it relates to the discipline piece, there is a lot going on with our kids in high schools right now. They are struggling with immense mental health challenges.
Thank you.
As a consequence
Time.
of COVID.
But you have the next question. This is our closing question. This has been a bitter or nasty campaign. What is the one positive thing you can say about your opponent? And feel free to use up to 2 minutes.
I'm going to say more than one positive thing because I think there's a lot of positive things I'm willing to say. I think, unfortunately, the tone and perhaps the perception of my campaign is that this is personal, and it's not. I was excited when I started working for my opponent in 2020 because I truly believe in reform prosecution. I was sad when I had to leave that office because I was disappointed with where we had gotten. I was sad to leave so many staff members and Commonwealth attorney members, people who still text me to this day, who I consider to be friends. I was sad to leave that behind. The team that was brought together in 2020 was fantastic. It's exactly the type of team that we wanted to have in Arlington County. It's exactly the type of team that Arlington County should expect of their Commonwealth Attorney's Office. That's why I focus so much on the fact that they've all left. We've lost such an opportunity to deliver on the promise of 21st century reform. I'll say something else. The discovery practice that we adopted when my opponent took office is exactly the type of discovery practice that we as prosecutors all support. We want to give opposing counsel as much information so they can have the best opportunity to put their case forward. Because that way, when we win at trial, we have buttressed the integrity of not only that case, but the integrity of the system. I think I'm saddened that at the end of this campaign, things are getting so immensely personal. It doesn't have to be like this. I think if we focus on substance, we can probably have the purest version of the debate about what reform should look like in the 21st century.
Thank you. Parissa, last question. What is one positive thing that you can say about your opponent?
Well, I would like to start with addressing the tone of this race, because the first words out of my opponent's mouth in an email were that I had broken my promises and that I had broken the office. And so it started out extremely personal. What I can say about my opponent is that it's great that he agrees with me on almost everything. And it's great that he thinks, just like I do, that kids should be treated like kids. And it's great that he says that he thinks that people should be sent to treatment. It's great that he says that my discovery policy was appropriate. What's baffling to me is, why would you, when the Washington Post has said that the administration's work is bearing fruit already, why would you change to somebody else? Why would you change to something untested? And so my opponent presents very well about what he thinks. I don't think the substance is there.
Ladies and gentlemen, that concludes our questions for the evening. Let's give a round of applause to our candidates.